By now you have probably heard about FBARs and the obligation to report offshore accounts. And maybe you have related FBARs with high net worth individuals that for many reasons have opened bank accounts in countries that are considered tax havens. But in reality, individuals without substantial assets may also run into FBAR issues. For instance, U.S. citizens working abroad who have opened bank accounts for purposes of receiving payments, and foreign individuals that have all their assets abroad and have become U.S. tax persons may be subject to FBAR reporting obligations. And that is why today I want to talk about FBARs and who needs to file them. Hi, my name is Andrea Aguilar, and I am an attorney at Counsel, a boutique planning firm in Miami, Florida, dedicated to helping global families and businesses protect their assets and leave a legacy. Well, what is FBAR? FBAR stands for Foreign Bank Account Report, and it is exactly that, a report that must be electronically filed with the Treasury Department. Just to give you a little bit of background, this reporting requirement began many years ago with the Bank Secrecy Act to prevent financial crimes like money laundering. And under this act, U.S. persons are obligated to provide information about their foreign financial interest if the aggregate value of this interest exceeds $10,000. But let's take a closer look at this rule. First, the persons that can be subject to these reporting obligations are both individuals and entities. And among the individuals, we have U.S. citizens, green card holders, and foreign individuals that have met the substantial presence test. Also, entities like corporations, partnerships, and LLCs created or organized in the U.S. may be subject to FBAR. Now, when the rule talks about financial interest, all of us automatically understand that to mean bank accounts. But most people mistakenly fail to recognize that financial interest also refers to mutual funds, insurance policies, annuity policies, investment accounts, etc. So that is something to keep in mind. Now, if you own this type of financial interest, you need to report them, even if you are using a nominee or even if you only have signatory authority on these foreign accounts. Another thing to remember is that the $10,000 threshold can be met by having different accounts that in the aggregate add up to $10,000 at any point in the year. But what happens if you have failed to comply with your FBAR reporting obligations? Well, in that case, you need to know that the penalties are pretty steep, and you can be subject to both civil and criminal penalties. The potential civil penalties are $10,000 for each non-willful violation, and the greater of $100,000 or 50% of the amount in the account if the violation was willful. Also, each year you didn't file is a separate violation. Now, the criminal penalties for FBAR violations are even more frightening. They may include a fine of $250,000 and 5 years of imprisonment, and these penalties may be doubled if the FBAR violation occurs while violating another law. And to make matters worse, all these amounts have to be adjusted for inflation. So to conclude, I just want to mention that the obligation to file an FBAR report is separate and different from the requirement to file your tax returns. Also, if you have failed to comply with FBAR rules, keep in mind that there are programs that can help you to become compliant. And finally, unless you're considering renouncing to your citizenship, there is no way to escape your obligation to report your foreign financial interest. And even if you are considering it, renouncing your citizenship may be a bit too extreme and will open the door to other tax consequences like the exit tax. Well, as always, thanks for watching. Please like, comment, and share this video. Also remember, great families plan for great futures. Who are you planning for?